A server room does not have to explode for a cyber incident to become a public safety problem. Imagine a digital system that coordinates emergency beds, a control network that keeps electricity moving, or a communications platform used during a disaster. If one of those systems is incapacitated, the effect may travel far beyond the organisation that owns it. That is the problem behind Sections 70 and 70A of the Information Technology Act. But there is a legal trap at the very beginning. A system may be vital in ordinary language without being a protected system in the statutory sense. The label does not arise merely because a manager calls an asset critical or because an outage would be expensive. This episode builds the classification step by step. Our fictional composite, Riya, works with a vendor supporting hospital scheduling software. She sees an unfamiliar administrator account make repeated remote access attempts. The activity looks serious. It does not yet prove who acted, why they acted, or whether the affected resource has been notified as a protected system. Riya's first task is therefore not accusation. It is disciplined triage. Preserve what she can lawfully preserve, identify the resource and its dependencies, find the relevant Gazette material, and escalate through the organisation's authorised security route. By the end, you should be able to separate 5 questions that are often collapsed into one. Is the resource operationally important? Does it affect critical information infrastructure? Has the appropriate government notified it? Who is authorised to access it? And which national cyber body has the relevant role? Section 70 supplies the statutory idea of critical information infrastructure, usually shortened to CII. It describes a computer resource whose incapacitation or destruction would have a debilitating impact on national security, the economy, public health, or safety. Notice the language. The question is not whether interruption would be inconvenient, it is whether the impact would be debilitating in one or more of those nationally significant dimensions. A computer resource is also broader than a visible website. The Act's terminology can reach computers, systems, networks, data, databases, and communication devices, depending on the precise provision and facts. In a real assessment, the front-end application may be only the easiest thing to see. Authentication services, network links, cloud control planes, operational technology, update servers and specialist suppliers can be dependencies of the essential function. That makes mapping important, but it does not permit us to invent a legal classification. A business impact analysis can show what would happen if an asset failed. An architecture map can show where access travels. A threat model can show plausible attack paths. None of those documents is itself the Gazette notification required for protected system status. They answer related but different questions. For Riya, the hospital application may support public health, but she still needs to identify the exact resource involved. Is the suspicious account touching a customer-facing portal, an internal support tool, a clinical database, or a gateway into a separately notified environment? A precise noun is the beginning of legal analysis. The phrase critical infrastructure is not a magic conclusion. It is an invitation to identify the resource, the consequence of incapacity, and the official act that gives Section 70 its sharper legal effect. A protected system is created through legal action, not through a cybersecurity adjective. Under Section 70, the appropriate government may declare by notification in the official Gazette a computer resource that directly or indirectly affects the facility of critical information infrastructure to be a protected system. That wording creates a source discipline. Find the notification, read its description of the resource, check whether it is still operative and whether later material modifies it. Then compare the resource in the notification with the resource in the incident. Similar names are not enough. A parent organisation may operate many systems, while a notification identifies only particular facilities or resources. Section 70 also allows the appropriate government, by written order, to authorise the persons who may access the notified protected system. This is why an administrator account is not the same thing as legal authority. technical capability, an old password, a vendor contract, and a written access authorization answer different questions. In practice, a sound review compares the user identity, employer or supplier, role, approved purpose, time window, source device, and access route against the authorized list and current access control records. It also checks emergency access procedures, because unusual access is not automatically unlawful if a valid contingency route was invoked. Riya should therefore resist two opposite errors. She should not dismiss the event merely because the account existed in the directory, and she should not declare a Section 70 offence merely because the login looked unfamiliar. The notification and written authorization framework must be established first. Preserve the logs, but preserve the limits of the conclusion too. A good incident note can say, repeated attempts observed, account ownership unconfirmed, resource classification under verification, written access authority not yet located. That is more useful than certainty manufactured before the governing documents are read. Section 70 treats access with unusual seriousness. A person who secures access or attempts to secure access to a protected system in contravention of the section may face imprisonment extending to 10 years and a fine. The attempt language matters. The protected boundary need not be successfully crossed before the provision becomes relevant, but a high maximum sentence does not eliminate the need to prove the legal and factual elements. Start with the notified protected system. Then identify the conduct said to be access or an attempt. Establish that the event was directed at the protected resource, not merely at a public page owned by the same institution. Verify timestamps, log sources, time zones, and retention gaps. Determine whose credentials, device, or network path were involved, while remembering that an account name or IP address is not automatically a human identity. Finally, compare the conduct with written authorization and any valid emergency procedure. This is where Episode 8's evidence chain returns. A security alert is a lead. The underlying logs, configuration records, identity provider events, and forensic acquisition history determine what the alert can prove. Riya should preserve the native records through the authorized team, record the clock source, and avoid changing the target system simply to investigate. If the vendor has an incident response contract, its scope does not automatically authorize every employee to enter a protected environment. Equally, a failed login may result from a stale service account or misconfiguration rather than malicious intent. The legal method holds both possibilities open while evidence is collected. Section 70 is not a slogan meaning important system plus suspicious activity. It is a structured inquiry. Notified system, defined boundary, access or attempt, absence of valid authority, attributable actor, and evidence whose integrity can withstand scrutiny. NCIIPC and CRT. In are often mentioned in the same breath, but the Information Technology Act gives them different statutory anchors. Section 70A authorises the central government to designate a national nodal agency for the protection of critical information infrastructure. NCIIPC performs that role. Section 70B makes the Indian Computer Emergency Response Team the National Agency for Incident Response. Protection of nationally critical infrastructure and response to cyber incidents can intersect, but the organisations are not interchangeable labels. A simple way to remember the distinction is to ask what the law is organising. NCIIPC's Section 70A frame is the CII protection ecosystem, identifying and safeguarding critical dependencies, coordinating with protected system entities and sectors, and supporting measures for the security and resilience of CII. CERT-In section. 70B frame is incident response, collecting and analysing cyber incident information, issuing alerts and advisories, coordinating response and performing the functions assigned by the Act and rules. CERT-In's 2022 directions also create reporting and operational requirements for covered entities, a subject addressed earlier in this series. In a major incident, an entity may have duties or coordination points involving both bodies, plus a sectoral regulator, law enforcement, customers, insurers, or contractual partners. The answer is not to choose one famous acronym and stop. It is to build a notification matrix from the actual classification, the actual incident, and the current official directions. Riya's vendor should know which customer environment is in scope, who owns the regulatory relationship, and which reports the vendor must support. She should not independently send sensitive protected system details to an unverified address. The internal CISO or designated incident lead should use established channels, minimize unnecessary disclosure, and keep a record of what was reported, by whom, when, and under which obligation. Section 70A says that the national nodal agency is responsible for all measures, including research and development, relating to the protection of critical information infrastructure, and that the manner of performing its functions is prescribed. The NCIIPC rules give institutional form to that mandate. For learners, the key point is that protection is not limited to reacting after malware is found. It involves understanding the essential function, the technology and non-technology dependencies that sustain it, the threat landscape, and the consequences of failure. It also depends on coordination, because no national body operates every network, and no single operator sees every cross-sector dependency. This changes the way an organisation should describe its environment. A list of servers is useful, but it is not the whole story. Begin with the service that must continue. Map the processes and information needed to deliver it. Identify systems, communication links, identity services, facilities, personnel, maintenance channels, and third parties. Ask where a single failure could propagate. Record assumptions, and validate them with operational teams. This is resilience work, not merely compliance theatre. Yet the legal distinction remains. An asset map supports protection and notification analysis. It does not itself create protected system status. Riya's customer may depend on the vendor's update service, even if that service sits outside the customer's premises. That dependency should be assessed and secured. But whether the vendor service is itself within the wording of a Gazette notification requires a document-specific answer. The disciplined approach is therefore two-layered. Operationally, map broadly so hidden dependencies are not ignored. Legally, map precisely so the notified boundary is not stretched by intuition. When those layers are kept separate and then connected, technical teams and lawyers can communicate without one replacing the other. Subsection 70(4) requires the central government to prescribe information security practices and procedures for protected systems. The Information Security Practices and Procedures for Protected System Rules 2018 provide that more specific governance layer. This episode is not a substitute for reading the rules or an entity's directions, but three ideas are central. First, protected system security requires named responsibility rather than an anonymous promise that IT will handle it. The rules provide for designated security leadership and organisational oversight. Second, the security programme must be documented and connected to the protected system's risk, architecture, operations, and dependencies. Third, governance is continuous. Access, monitoring, change, incident response, audit findings, and remediation have to feed back into oversight. A policy document that is never compared with the live system is not a control. For Riya's vendor, the practical questions are concrete. Who is the customer's designated contact? Who may approve remote access? Are vendor identities individually assigned or shared? Is privileged access time-bound and recorded? Does the maintenance channel enforce strong authentication? Are logs protected from alteration and synchronized to a reliable time source? What happens when a support engineer changes role or leaves? Which changes need advance approval? How are urgent fixes reviewed after the event? These questions matter even if the vendor itself does not own the notified system, because supplier access may become part of the protected system's risk surface. The vendor should receive only the access needed for the approved task and period. It should understand contractual and regulatory escalation routes without claiming statutory authority it does not possess. Most importantly, the governance documents should match reality. If the authorised person list says one thing and the identity platform says another, the inconsistency is itself a risk to resolve before an incident turns it into evidence. Remote support is where operational convenience can collide with protected system discipline. A supplier engineer may authenticate through the supplier's identity platform, cross a customer gateway, and reach a resource governed by the customer's statutory and security controls. Each step answers a different question. The supplier confirms who the worker is. The contract describes services. A ticket or change record describes the task. Written authorization identifies who may access the protected system. Technical controls enforce a route and time window. Logs record what actually happened. None of those layers should be assumed from another. A broad contract to provide maintenance does not necessarily mean that every employee is an authorized person under Section 70. A valid written authorization does not justify using a colleague's credentials. A successful login does not prove that the activity stayed within the approved purpose. Good design makes the lawful route the easy route. Individual accounts, multi-factor authentication, just-in-time privilege, session recording where appropriate, command logging approved source devices, rapid revocation, and an emergency process that is both usable and reviewable. Riya's unfamiliar account may turn out to be a newly created support identity. If so, the organisation should still be able to show who requested it, who approved it, what system it could reach, when it expired, and what actions were taken. If those records do not exist, the incident becomes harder to classify, and the access model is harder to defend. The response should therefore examine both the event and the control environment. Did an unauthorised actor attempt access? Did an authorised actor use an unauthorised path? Did the system permit more than the written authority allowed? Or did a monitoring rule flag legitimate emergency access? Clear records let the organisation answer without guesswork. When a suspicious event touches a potentially protected environment, the response has to move quickly without collapsing legal questions. Begin with safety and continuity. If the event threatens an essential service, authorised responders may need to isolate an account, block a route, or move to a resilient mode. Record who made the decision and why. Preserve the evidence needed to understand the event, including native identity and system logs, alert logic, relevant configuration, the clock source, and the authorization records that define the lawful boundary. Avoid unnecessary exploration by people who are not approved to enter the environment. Next, classify along parallel tracks. What happened technically? Which resource was targeted? Is that resource within a protected system notification? Was access secured or merely attempted? Was the actor authorised and for what purpose? Does the incident fall within a current CERT-In reporting category or direction? Are there NCIIPC, sectoral, contractual or customer routes? A reporting matrix should assign an owner, deadline, channel and minimum information for each obligation. It should also prevent contradictory accounts from being sent by different teams. Riya's role may be to preserve vendor-side logs and notify her incident lead, not to decide the customer's statutory classification. The customer may own the notification and national agency relationship, while the vendor supplies facts. That division of responsibility should be established before incidents, but it must not become an excuse for silence. If a contract requires prompt notice, the vendor should follow it through verified contacts and keep evidence of delivery. Language matters. report observed facts, affected services, containment actions, and confidence levels. Separate confirmed information from inference. Do not publicly identify an attacker because an account name resembles a person. A protected system incident can be legally serious and operationally sensitive. Accuracy and restraint are part of the response, not delays to it. A protected system conclusion should be reproducible. Another careful reader should be able to follow your sources and reach the same classification or identify exactly where the disagreement lies. Start with the current Information Technology Act on India Code. Read sections 70, 70A, and where incident response is relevant, 70B. Then locate the subordinate rules. The NCIIPC rules and the 2018 Protected System Security Rules. For the particular system, locate the official Gazette notification and any modifying or rescinding material. Record the notification number, date, notifying authority, and exact description of the computer resource. Do not rely on a news report, an organisation's marketing page, or a secondary list as proof of notification. Those may help you find the source. They do not replace it. Next, identify the written access authorization and the organisation's current governance records. Because access lists change, record the date at which the conclusion is made. Finally, map the incident facts to the legal material. A compact table can carry 5 columns: proposition, official source, exact resource or person, evidence in this incident, and confidence or gap. One row might say that a specified facility was notified. Another might say that a named role was authorized during a defined period. A third might record that the suspicious account did not map to the authorized list, with identity attributions still open. This method prevents a common analytical leap, using the importance of an organization as a substitute for the legal status of every system it owns. It also exposes stale documents. If the team cannot locate the current authorization order, that is a governance problem requiring escalation. The goal is not to produce paperwork after the event. It is to know before the event which source controls each consequential decision. Apply the sequence to Riya. She sees repeated remote attempts by an unfamiliar administrator account during the night. First, she records the alert identifier, source system, timestamps and time zone without copying sensitive customer data into a personal tool. Through the approved incident route, the team preserves the native identity provider and gateway logs. Second, it identifies the target. The account reached a vendor support gateway, but the available record does not yet show successful entry into the customer's protected environment. That difference matters. Third, the customer checks the Gazette material and confirms which resources are within the notified boundary. Fourth, the teams compare the account and the individual behind it with written access authorization, the maintenance ticket, and emergency access records. The account was created for a contractor whose approved work ended the previous week, but revocation had not completed. That finding shows a control failure. It does not, by itself, prove that the contractor initiated the attempts. Fifth, forensic review links the attempts to a managed laptop that had been reported lost. The organisation now has several possible legal and security paths, but the language should still track the evidence. It can confirm unauthorised attempts against the gateway, an expired business purpose, delayed revocation, and a lost device. It should say separately whether the attempts were directed at the notified protected resource, whether Section 70's boundary was engaged, and who can be attributed to the activity. Notifications to the customer and relevant authorities follow verified channels, while containment revokes the account and certificates, blocks the device, and reviews similar dormant identities. The case illustrates the purpose of disciplined classification. It accelerates the right actions because the team knows which facts are missing. It does not slow response by demanding courtroom proof before containment, and it does not turn an urgent alert into an unsupported public accusation. Before you say that Section 70 applies, ask the questions in order. 1. What exact computer resource is involved? 2. How does its incapacity or destruction connect to national security, the economy, public health or safety? 3. Has the appropriate government notified that resource as a protected system in the official gazette? 4. What is the notified boundary? 5. Who is authorised by written order to access it? 6. What access or attempt is alleged? 7. Which logs and records prove the target, route and time? 8. Can the account, device and human actor be distinguished rather than assumed to be identical? 9. Was the activity outside the purpose, period or method of valid authority? 10. What immediate containment protects continuity without destroying evidence? 11. Which NCIIPC, CERT-In, sectoral, law enforcement, customer or contractual routes apply? 12. Which propositions are confirmed, inferred or still unknown? Keep the institutional roles clear. Section 70 defines and protects notified systems. Section 70A supports the National Framework for Critical Information Infrastructure Protection through NCIIPC. Section 70B anchors CERT-In's National Incident Response role. The bodies may coordinate, but the statutory functions should not be blended into one acronym. Keep the status language clear too. Critical in an operational assessment is not automatically protected in law. A contract is not automatically written access authorization. An administrator account is not automatically a person. And an urgent incident is not a license to skip source verification. Riya's fictional case closes with the account contained, the evidence preserved and the protected boundary checked from official material. No real person is accused. In episode 10, we move from protecting critical systems to trusting electronic transactions. The controller of certifying authorities, India's root trust chain, digital signature certificates, e-sign, revocation, and the difference between a valid signature and a true statement.